thought Zion was up.
What's that?
I thought Zion was still in his exam.
No, I was up on cross already.
Well, Judge, they had an objection at the end. I don't think it was quite done. I mean, we need to figure out that report.
It's still privileged, so you guys are supposed to avoid it.
I think what he's testified to it. Is the jury going to get an admonition on this? Or?
Well, how can I admonish them on it?
Oh, excuse me, I misspoke. Is that going to be? Are they going to be advised to disregard that question and answer?
Well, we were going to talk about that before we started. We just have technical difficulties going on right now.
Understood, Judge. I'm just.
I mean, I know that.
Well, according to Paul, there's no internet hooking into it. And someone has been playing with this since I last left it, because I had to take it all back down and bring it all back up. And then somebody came in and turned it off, and we had to bring it back up again.
That was me. I copied it. I don't see the
Okay. Why don't you go back there and tell them we're having Monday morning technical difficulties, and we should be with them momentarily.
They know. We have one person we're waiting on.
Probably stuck in the west side traffic.
Yeah.
Here's another reference to that.
Some of the searches on here.
Okay, so
Go Disney World. My Wordy is the
thank you. I
game.
have no further questions. Prosper survives.
No, I'm signing as me. These are yours?
Those are mine.
Dr. Gina Moody would be mine.
No, you signed it on my laptop.
Yeah, but I'm getting my mail. I have my mail, but the Google search engine's there.
You're signing it.
In Google, how do I sign out?
Do you have a Google sign that you use to
I don't know. I'm not going to mess with it now.
Yeah.
jurors that hasn't made it in yet. I think they're hooked up in that West Side fiasco this morning.
This is subject to criminal production.
I wonder if you could bring over the portable TV and hook that in.
Just use the closed system. Yeah.
Yeah, 11:14. You just said I thought you had all those yesterday.
much?
No? All right, Paul, are the mics gonna work?
Yes, good.
Well, we can't put it too far back, because he's a walker. That's probably good right there. That's the best I can do, guys. Until I can get documents shown. Now, will they be on our screens too? Or just on this?
Well, I get to be on.
If we can get it in a couple minutes, sure, but if not, we'll go with what we got.
With no control.
No, that's not, where is this going to be hooked up to?
To the overhead.
I don't have anything voted on my laptop. I was relying on the overhead.
So I'm going to have to lower, Brad?
That's my issue, is I don't have anything scanned. And because the first day I started to use things on my laptop, I'm like, no, not working, so I was
Hold on
trying
for a second. Let's see if we can get it hooked up.
We still are waiting on a juror, so I mean.
Detecting device. That's a start. No internet. We can't do it today. Did we not pay our bill to tabs or something? I'm in. Just set up. You don't have a TV remote, but you do. Okay. You guys have just the overhead screen. That's it. It's on here. All right. We can't see what's going on it, so I have to adjust accordingly.
Can we move it back a little bit? So that way if I need to see it, what's on the screen, it's, yeah, what I'm pointing at, that might prove challenging.
Well, I got the jurors need to see it too.
Somewhere in the middle, I guess.
Let's see, then you got that juror's gonna be blocked out on the bottom.
Well, maybe we could test something and see. Test the document and see.
Mr. Thomas, can I bug you for a second to come up here and look at something?
Oh, sure.
Put it on there. Can you see that from there? Or is that put in the way?
So maybe like the lower left eighth of the screen or so is blocked?
Yeah.
Or the left turn?
Why don't you move it a little forward then?
That one doesn't have a microphone, which we're using as an extra table.
That's his crutch.
You know what, right there, I think that should work fine.
Can you see there, Mr. Thomas?
Yeah.
Okay. We'll make this work. Thank you, Bob. Let me know when this is hard, my friend. Got them all? Okay, well, we're going to put some stuff on the record. Huh? Of course.
Should I bring our client, Judge?
We need a couple of minutes here first.
Send it tonight.
Okay, we're on the record. We're currently waiting on one juror. Everybody's present. Just to put a couple things on. We have some technicality issues with the Jazz system. For some reason, the internet's not hooking in. We brought in a portable TV. It's facing the jury currently. It's hooked into the overhead only. Paul is currently trying to get hold of the Jazz folks to see what the problem is. He's already talked to the tech people over at the main computer center for the courthouse. Everything looks good there, so I don't know if it's a technical issue with them or not. I think that's got that issue pretty much. Paul's going to keep us informed as to what he finds out, so we're going to go with this. We broke up the other day. A decision was issued, and there was some collateral issues. Mr. Baez.
Yes, Judge, I understood your order after we received it. The only issues that I think weren't spelled out for us were, of course, how we are going to cure Dr. Roth's testimony where he made comments referring to documents that are privileged, thereby giving us the inability to cross-examine him on those points. And that was number one. And then the other issue, I think, on Swanner would be we would request that the questioning of Dr. Swanner be outside the presence of the jury so we can clear up that issue as to what report he was referring to and see if there's any further issues rather than, of course, having to go through this whole stop and break until we figure out where we are in terms of that, of what he was in fact relying on, if in fact he was relying on anything at all. So in light of that, I think those are the two present issues for the court to determine as to how we're going to move forward on those points.
Sam?
Thank you, Your Honor. Pursuant to your order, we would ask that Dr. Roth's testimony stand as it is. This is not newly discovered. In response to the defense subpoena twice, it was told to them that this report is based on confidential material. We are providing it as a response to your subpoena, and we don't waive that privilege. So this is not newly discovered as regards to Dr. Roth. They were fully aware of where he was getting that information based on privileged material. In fact, we, as attached to our motion, Judge, were some emails between Ms. Grubb and Ms. Manetchi regarding this document specifically as to stipulating as to its authenticity, which was agreed upon as long as a proper foundation was laid, and Dr. Roth testified personally as to it. So we don't believe that there is any further clarification needed for Dr. Roth's testimony. Dr. Swanner's testimony, hopefully we can arrange that later this week, and we'll deal with that when we get to it. Thank you.
Judge, we would respond to Mr. Zion by saying, first of all, it's not a report. He's referring to having access to privileged documents, and this is his conclusion or things that he jotted down after going through privileged material. So absent having that privileged material, we can't cross-examine him on it. We were, of course, aware of that, as he points out, but also aware that we weren't going to have access to that privileged material. So I don't think that changes the fact that we have a confrontation clause issue. He testified about some phantom report of which, in fact, is his work, his review of certain privileged documents, and he wrote down what he chose to write down, not some kind of report spit out by a computer somewhere at Mount Carmel. So,
But didn't you solicit the information?
I haven't questioned this witness yet. You're talking about prior during pretrial motions?
Subpoenas.
Oh, excuse me. Yes, subpoena. Excuse me. It's early. So yes, we did, but this is in the fact-finding phase of the case as to whether we get some information and whether it's admissible or not are two completely different things. And in this case, it wasn't admissible because it came from privileged documents that the hospital still maintains and chooses to maintain the privilege. and the court ruled. So, this is all based on, if you look at the timeline of events, there's a court order precluding us from accessing this information. In addition to that, there's a witness testifying or writing things down for which he got from this information. Yes, it's great to have, but if we can't cross-examine him on it, this is an adverse party who is an interested party in the case, and we should be able to properly cross-examine him with the documents and with the proper materials that we would have to be able to accomplish such a thing. I would like to have what he relied on, and that's the only way I can properly cross-examine him. If you looked at these papers, I need to see them too to be able to see if you're lying or not, and I can't. So they can't have it both ways, having their cake and eat it too. And in fact, the prosecution was aware that this was based on privileged information and improperly solicited over our objections. So this is the mess they created, and not only with one witness, but with two witnesses, and we've been dancing around and tiptoeing around the tulips the whole time with these report issues. It's not something that they kind of slipped out. This is something the court has worked diligently to try and make the right calls based on the limited information that it has, and as well as all the other parties involved. So they can't claim that this is some kind of a accident or mistake. They intentionally sought out testimony from a witness where they knew we couldn't cross-examine them on it. And I'll just leave it at that before I say it.
Okay, Dr. Swanner's testimony is a separate take to Dr.
Right, we're not talking about the current witness.
Right, Judge. I mean, it was clearly spelled out in a letter from Mr. Peterson in response to their subpoena, and then later on by Mr. Gobble from Jones Day as well, when a title was put on top of it to make clear what this data pull was. He had put that in, they had put that in the letter originally, saying this is based on privileged material to Ms. Menashe, and we're not waiving that, but here is the information you've asked for. And then when we met and asked, how do we know this is what that says, States Exhibit 27 prime, he said, well, it's in the cover letter, but I'll add it to this. And that was in November. He'll add the title to this. And he wrote another cover letter to both parties in November and said, here it is again. We've just put a title on it so it's clear what it is. And in that letter again, which is in discovery, which we've attached to our motion, it again states, this is based on confidential material, and it is, we're giving you the information, but we're not waiving privilege as to that confidential material. So, and then like I said, it wasn't like we were trying to slip anything in, Judge. We emailed them ahead of time and said, this is a very important document to us. Can we talk about its admissibility and the parameters of it? We attached that subpoena. Ms. Menashe responded. Okay, we'll work with you. So it's not like we snuck this in on anybody, Judge. And then it wasn't until it had actually been testified to that there was an objection. So this was not subject to any type of pretrial motion or a motion limited by the defense. So I would take exception to those characterizations. This was something that we had worked on, we had addressed, we had brought to their attention specifically that we were going to elicit through Dr. Roth, and it wasn't until the end of his testimony that there was an objection. So we would ask that his testimony stand at this point, Your Honor.
Had you just finished your testimony?
I just finished it, and then there was an objection based on...
You guys, I was busy trying to get a decision out on Friday for you guys, so...
I'm sorry?
I was busy getting a decision out on Friday. I didn't get a chance to talk to my court reporter about where we left off.
I believe we left off with me having no further questions, and then they asked to approach, and that's when all of this came to light.
Okay.
You ready?
Judge, may I respond to this last information given to the court? I realize they take exception with my prior comments, and I'm certainly going to take exception with these. But now, this is just straight up trying to mislead you. All of the emails that were sent from Ms. Grubb to Ms. Menashe were about this document. Had nothing to do with this document. In fact, we all had a sidebar with the court.
And the
court
waving
looked at this document.
documents around, the court report.
Sure. I'm sorry. States Exhibit, I'm sorry. States Exhibit 27 is what was the subject of the sidebar. It's what the prosecutors showed the court. We had Ms. Menashe come up, and she confirmed the conversation. We had this whole conversation at sidebar over States Exhibit 27. Now he's trying to pass off that this whole conversation revolved around States Exhibit this other States Exhibit 27, which is a completely different document. I don't know why he's labeling it the same.
27 prime is what it is.
I'm sorry?
27 prime. Little accent over it.
Yes. Okay.
That just shows us it's the same exhibit, just different format.
It is not the same. Well, it is not what was sent around, and it is not, and it did not have this title up top. So we're talking about two completely different things that would have placed us on this. To me, I read this and I say, okay, well, it's a summary document, and that's what it was passed off as. This then gives more information where they say, where it's titled, and I'm referring to 27 prime, where it states, all instances in which patients within Mount Carmel Health System hospital received a dose of fentanyl at or above 500 micrograms while not in an operating room setting or on a ventilator, September 2013 to September 2020. And it says all instances. I don't have anything to be able to cross-examine him on this. And I don't have any of the documents to be able to say, to be able to ask him, to be able to inquire as to whether this is all of the specific instances. This is one man's testimony based on one man's research, and he took it from privileged documents that we don't have access to. So for him to get up there and be able to testify to something that is a fact, we should be able to confront him on it. And then to try and pass these two documents off as if they're the same thing is simply just not appropriate.
Why wasn't this raised in your pleadings Friday?
I had no idea that they were going to try and pull something like this.
He labeled it on the record.
I saw him label it on the record, but I didn't have any idea what he was doing in terms of that. Well, all I knew is I was objecting to all this privilege stuff coming in, regardless of what he decided to label it as. But now, somehow, they're passing off an Excel spreadsheet to try and make it look like it's a computer printout, number one, and then adding some type of sentence or two which bases an actual conclusion of fact. And one, nothing could be further from the truth on that, in terms of that it is an actual computer printout, and two, there's no way to cross-examine him on this. That's it.
Okay. Well, I don't see a value in giving them some type of limiting instruction. It's privileged material. It should have never been solicited. It's out there, I realize, but am I going to bring accent to it by saying something to them?
I think we're going to assume that this jury, we all went into this case assuming that this jury was going to follow your instructions. And if you instruct them that they are to disregard that question and that answer and not consider it, I think in terms of the record, for appellate purposes, and for the final determination of this case, they have to be able to follow your instructions. And look, I don't like the fact that you have to point it out and bring it up to them at all, because it never should have been solicited in the first place. But we're in this position, so something has to be done about it.
Okay. You want to bring them?
Sure.
Anything else for the record before we bring them in?
Just so we're clear, Judge, are you going to give a limiting instruction or not?
I'm thinking.
All right. Well, if you decide to, we have additional things we would ask then after that.
What are you going to want in addition if let's say I do say you disregard the last answer and question? What else are you going to need?
We've asked to recall this witness. We will subpoena him and ask him to recreate that document, not using privileged information, see if it's possible.
But you can do that on redirect.
Not if you say we can't ask it. And not if you're limiting that question as being disregarded and stuff.
So do you want it on a sidebar? Or do you want to proffer it? Or what do you want to do? I'm still debating on whether I should give it or not because I don't think it's a particularly great idea right now.
Judge,
But that's my gut.
my understanding of this situation is they asked for this information, and they were provided this information with the understanding that we use these confidential Greeley reports as a way, because the information had already been gathered. So we looked into those reports that the court had deemed confidential and produced this for you and told them that. And then when I was like, what does this document say? And that was, as I said on the record, I wasn't trying to sneak anything in. 27, I believe, is what was shown to Mr. O'Brien. I just had it mislabeled. And 27 prime is the report that clearly says Husel's the only one doing this in the whole system. So, and that was just a mislabeling. We had 300,000 documents, and I said that clearly. So Dr. Roth used the confidential material to respond to their subpoena, told him he was doing that, and here it is. Only Dr. Husel's using it. They were trying to find every other doctor in the system that does what Dr. Husel does. Well, guess what? No other doctor in the system does it. Here's your report. So, and then Mr. Gobble in November said, I'll put this clearly on the top of it. That's what 27 prime is. Then we said, hey guys, we want to introduce this, and you saw those emails relating to 27 prime. So we believe, we don't know because of your admonition, we can't talk to Roth during the weekend. We believe that because his report is just based on medical records of patients at Mount Carmel in the system that they can go through it long form without using the work already done by Greeley, we think anyways, and reproduce that report, assuming they come to the same conclusions, assuming that Greeley was correct, and then present all of that. So
One second, guys.
So if the court says you can't use this information, you have to disregard it, I think the only way we can, get that in front of a jury, which I believe is relevant, is to ask Dr. Roth, we'll subpoena them, and we've got another 8 weeks here together, so see if you can do it within 8 weeks and ask to recall him, would be our option B on this.
Okay.
Thank you.
Of course, we would object to that. We weren't given proper notice of that. This is now, this is basically an expert report now because here's the thing.
Okay, it's an issue of fact, though. It's not an opinion.
No, it is an opinion because he's reviewing records.
If they go through the records and they produce A to B, that's a fact. It's not A, I believe B.
What it is him going through records and making determinations that constitute these facts. So that's the issue here. And we keep calling it a report. There is no report that could be ran to see if this was in fact only Dr. Husel. This was something they had to do by hand. So therefore, and by reviewing records, so therefore he had to come to conclusions and opinions.
Okay, you made your record.
I have.
Okay, let's bring the jury.
So do we know what the court's going to do? Or?
I know what the court's going to do.
We would like to know.
Well, you'll find out, won't you? I am not going to give a curative instruction at this point in time. I want to see where it develops.
So how do I address this in cross-examination? That's where I'm...
Carefully.
Judge, I need a little more guidance than carefully.
Well, I'm still trying to figure out how all this post stuff's relevant anyway. Okay? But that's aside. I would just leave it alone for now get going for a while, and then we can see where it goes, and then I can, if I change my mind, I will let you know. Or you can try to tackle it, but you got to do it carefully.